I am pleased to introduce Travis Finchum with us this morning. Thank you so much, Travis, for taking some time out of your Saturday morning away from the family to talk about special needs trusts and ABLE accounts. I've known Travis for probably over a decade now. In some previous work before ABLE existed with the works with the ARCs across the state. But Travis is a board certified elder law attorney since 2002. He's the president and founder of the law firm Special Needs Lawyer. He's also an advocate and an account administrator for an ABLE account as well. So before we get started with Travis, we're going to do a quick poll just to get a sense of how many people have special needs trust. This will help Travis prepare to see if where we're at and be able to walk through special needs trust and give everybody some words of wisdom. So we got about 10 more seconds or so. Give everybody opportunity to respond. And just great attendance overall. It's great to see this many people on a Saturday morning. So we'll go ahead and end the poll here and share that. So that's great. So 32% yes. So that's great. You'll get some insight and maybe some things you didn't know about special needs trust. And for those, hopefully this is a great learning opportunity for the bulk of you, about 68%. So great with that. But with that, Travis, I'm going to turn it over to you to share your screen and walk through special needs trust and ABLE accounts. Thank you again.
Great. Thanks, John. Take me a second here. Let me share my screen. So hopefully you're seeing my special needs trust and ABLE account screen there. This is me. I'm this guy over here on the far right. We are a law firm in the Tampa Bay area, actually Clearwater. We have 4 board certified elder law attorneys. A lot of people ask why elder law attorneys are doing this kind of thing. There's not a recognized specialty at this time in special needs planning. There are some national organizations that encompass different professions that deal in special needs, whether they're lawyers, financial advisors, even organizations. And one of those that I'm involved with is the Academy of Special Needs Planners. And so there are groups that are out there, but there's not a recognized specialty for certification. So many of the attorneys that deal in this kind of law are also dealing with elder law. And it kind of makes sense because a lot of the benefits that are available for our elders, like Social Security, Medicare, Medicaid, and Medicaid waiver programs, are also there for our younger population with differing kinds of disabilities, but intellectual and developmental in particular. So I've been working in this space for, actually this year it's been 30 years. And my practice has evolved through those years. I started working mostly just with elders. Then I got into a younger population, dealing with families with a child with mental illness. And then 17 years ago, my practice changed again when my daughter Lillian was born, who has Down syndrome. So when she came along, I looked at my wife and we said, we really don't know enough about all of this and this whole new population. So I've jumped into that and have been doing special needs planning in addition to the elder law since then, actually even before then. I started a company that administers special needs trusts 19 years ago. So I was doing that before my daughter even came along. I wanted to, as I was listening to some of the earlier sessions, I was thinking about my answers to a couple of those questions. And I know I was right there along the way with Catherine when ABLE accounts came along. I was a bit skeptical at first, but I went ahead and jumped in, and I figured if I wanted to learn how to do this, who better to test it out on than my daughter? So I opened up on July 2nd, which the accounts went into law on July 1. So I'm not account number 1 like Jen, but I've got to be one of the first few that I opened up an account for my daughter. And I wanted to learn how to do it, how to go online, how to open the account, what questions they were going to ask. So as I went through, I did screen captures of each of the screens, and I made a little booklet so that I could then help my clients. And I have helped many, many clients open up Able accounts, but to give them kind of a little booklet on what to expect. Now, the screens have changed and the process has changed a little bit since then, but it's still a pretty simple process. The other thing I did is while they were talking, I pulled up my daughter's account. And when they were talking about the investments, and none of them got into this kind of detail. I don't work for Able. I speak a lot with my clients about it, so I don't have an interest one way or the other whether individuals open an account. But when I opened my daughter's account, I invested half of the money in the most aggressive one that they had, which was a growth portfolio, and the other half in a moderate portfolio. And since it's been opened, my daughter's account has grown 59.98%. We're going to round that to 60%. So her account is up 60% tax-free since I opened the account for her. So that's really difficult to compete with at any level. And when we're going to talk about special needs trusts, we're going to do a lot of comparison. And that's one thing that Able accounts will always be able to beat the special needs trusts on, because of the tax-free growth. So that money has been growing, and we're not paying taxes on it now, and we're probably not going to be paying taxes on it later on, because we're going to use it for those qualified disability expenses. But before Able accounts were available, special needs trusts were the only game in town, really. And so we're going to talk about them because they're still there. And I agree also with some of the earlier presenters that they're still necessary and they can work very well with Able accounts. And so special needs trusts, a lot of people think they maybe were only around since a major federal law changed in 1993. Well, that brought us one category of special needs trusts, but they've been around for many, many years before that. And as John mentioned before, one of the big things about special needs trusts that we're going to talk about is the source of the funds make a difference as to the type of trust that we would establish, and also the rules that go along with it. So with that, we're going to dive in and talk a bit about special needs trusts. I've taken most of my slides in this particular presentation about Able accounts themselves and taken them out because the Able accounts were already talked about, but I've left a chart at the end that we're going to spend some time on, kind of doing a comparison of the different kinds of special needs trusts and Able accounts, so we can see, because I was reading the questions that were going in the chat feature, and some of them were right on point on some of the things we're going to talk about. The other thing that I would say is, this goes back to John or Rachel, as far as questions go, I'm happy if you have questions as we go and you're monitoring them, if you want to interrupt me, or I can leave some time, a little bit of time at the end to go through and go through some of those questions. I'm just not going to be able to read them while I'm going through and answering. I see John's giving me a thumbs
Good,
up.
yeah,
So,
good segue. But yes, that Q&A box, you should see that. That's a great place to put your questions. If we have some time at the end, we'll go to them and answer as many as we can, and if not, we'll do our best to get back to you. So good plug in there, Travis. Appreciate it.
Thank you. I can leave a little bit of time at the end for questions, because a lot of those earlier questions were special needs trust related as well, and I know you kind of intentionally left those for this session. So now we're just going to focus on special needs trusts, which again have been around for a long time and haven't really changed a whole lot. There's been a few little modifications through the years, but the basic concept and the idea of the special needs trust is not so different than the goal of Able accounts. The idea of a special needs trust is that there's an individual at the center of it, the beneficiary, that we want to provide for. We want to leave some resources for that individual that's going to give them a better quality of life than they would have had without the trust and without the funds in the trust. But we also, in order to do that, we want to be careful that we're not disturbing any really important and critical public benefits that they may be getting. A couple of those were mentioned earlier, and I'm also not going to go into great depth on these public benefits because you've got an expert on those coming on a little bit later regarding Social Security benefits and also one of our Medicaid waiver programs. But I want to give a little bit of an overview just so that we can have the context for how special needs trusts work. So the idea is we want to keep these benefits intact and have the money in the trust be there to pay for extra things and to supplement those other benefits, not to replace them. And so sometimes you'll hear a special needs trust referred to as a supplemental needs trust. I've heard them referred to as a lot of different terms. I had one where it was a new one for me. I had a gentleman who was an attorney from New York who had retired to Florida. This is years ago, and I learned that he had a son with mental illness. And he came to me and asked me about a luxury trust. Have you ever heard of a luxury trust? Have you done one of those? And I said, I'm not really. A luxury trust sounds like an expensive thing with tax planning and all this other stuff. I said, tell me about what it is. And he said, it's to pay for the luxuries in life, the things that are not the basics, to not necessarily be used for food, clothing, shelter expenses, but the extra things in life that you wouldn't get from any of these programs. And I said, okay, you're talking about a special needs trust. So it can be luxuries. It can also be basics. We here in Florida have a lot of things that we love about living in this state. We love the weather. We love the sunshine. We also love the fact that we don't have a state income tax. Now, that last issue becomes a problem if we're looking for this second bullet here, public assistance programs. Florida is at the very bottom of the country. In fact, I can't say the bottom. We are 50 out of 51 possibilities because the District of Columbia is included in there in what we spend per capita through our government programs on individuals with intellectual and developmental disabilities. There's a study out of the University of Colorado. It's called State of the States. And every year they update public spending and funding and per capita funding for individuals through state programs. And we're at the very bottom. So our programs do not provide nearly what other states provide. So it's really important that we set aside some money and that we can supplement those benefits. It's a challenge to get the Medicaid waiver program to begin with. There are more people on the waiting list than there are people getting services. So if you have not applied for our Medicaid waiver program, again, they're going to talk about it a little bit later, you need to apply for it and at least get on the waiting list. And maybe you'll get a slot. And if you do, just realize that once that person starts receiving funding, the amount that they're getting is the lowest per capita in the country except for one other state. Incidentally, if you're trying to guess the other state, it's actually Nevada. It's not ones that you might have thought in the Deep South. So this is why it's important to be able to set aside some funds. We want to be in control to the extent we can in providing services and extras for our loved ones. So my next is we would generally go into somewhat of an in-depth discussion into some of these programs, and I'm only going to touch them briefly because there's a whole session on them. But you've got to know if we're talking about what kind of programs are we looking to maintain. Well, there are three sources of income on this screen that are all administered through the Social Security program. Other programs or other benefits, I should say, through Social Security that aren't even listed on here would include retirement and dependence benefits, so that if a person who's working becomes disabled and has minor children, they can get a Social Security benefit until they're adults. These are programs that are dealing mostly with the type of population that we're talking about today. There is a Social Security Disability Insurance Program. That's the first one, SSDI. And if we remember that the I in SSDI is insurance, it'll help us distinguish that from the SSI program, which is supplemental security income. But SSDI, if we also remember that it's an insurance, most of us would understand we don't get insurance unless we buy it or pay for it. So you can have health insurance, you can have car insurance, you can have homeowners insurance. This is an insurance policy that we get as a taxpayer when we pay our taxes. So when you get your paycheck at the end of the week and you look at it and you see all of the deductions from it for FICA, the federal deductions, which includes Social Security taxes, Medicare, and your other taxes that are maybe being withheld from your check, those funds go into the federal system. And some of it goes into our retirement program so that when we hopefully reach our retirement age and we retire, we'll get an income stream back from Social Security based upon what we put in. But we're also putting money into a disability trust fund with the federal government. That's basically buying a disability policy from the federal government when we just pay our taxes. We don't ever get a policy or we don't get anything in writing about it. But if we have worked and paid into that system, we can actually get a disability benefit, a check back from the government, even if we're not retirement age, if we become unable to work. So when we're doing that, though, we're also putting money potentially aside for our dependents who have disabilities. Some who are minors will get a benefit if we're drawing Social Security, either because of retirement age or because we become disabled as a parent. But we also are putting money into a benefit for our adult children who have a disability. And that's the third bullet on here, the disabled adult child benefit. So we've got to realize that there's a benefit to actually paying our taxes. The more you put in also, the more you will get out later on, but also the more that your dependents will get out. So the SSDI benefit, because it is an insurance program, it's not based on financial need. So an individual eligible for that benefit can have a lot of money and maybe doesn't need a special needs trust. There may be reasons to have the special needs trust anyway, but we don't need it just to maintain an SSDI check. Similarly, the disabled adult child benefit, which is for a son or a daughter of a worker who has paid into the Social Security system, if the child's disability occurred prior to age 22. Now, this is different than the able account age, which is age 26. So there's a lot of keeping track of these programs and at what ages there's a critical decision that has to be made. But if the beneficiary's disability occurred prior to age 22, they can draw on a Social Security check based upon their parents' work history. And that benefit also is not going to be based on financial need because it's based upon the parent having worked and put into the system. So a child on the DAC benefit doesn't necessarily need a special needs trust to keep that benefit. What we're going to find, though, is that there are other benefits in addition to these that the individual may be eligible for where the trust may be helpful. You can find out a lot of information about these programs at the Social Security website, which is listed here at the bottom. It's ssa.gov or it's socialsecurity.gov. These are income streams for the individuals. The one I want to focus on is the SSI program. We mentioned that earlier in the program. SSI stands for Supplemental Security Income. This is a Social Security check for an individual who can't get Social Security from any other source, or if they get Social Security from another source, it's not very much money. And the supplemental check is designed to raise the individual up to a minimal level to help cover their food and shelter expenses. The maximum SSI check right now at the federal level is $794. So it's almost $800 a month. It's probably not enough to live on independently, and certainly not enough to live on well independently, but it is designed to bring the person up to a minimal level. If they get income from another source, through maybe a disabled adult child benefit or the SSDI program, they may get two checks, but they won't combine to more than the $794 plus 20, because there is a $20 disregard for other forms of income. So if you're getting a DAC benefit, they'll disregard the first $20 of that, and then you'll get an SSI check that will get you up to the $794 plus 20. So these are income streams. The SSI program is based upon financial need. It is a welfare-based program. None of the money that's paid out through the SSI program comes from our Social Security system or the money that we pay in our Social Security taxes. This is general welfare money. It comes out of the general tax revenue welfare fund that the federal government has. There is no state addition to this. So Florida does not provide additional funds on top of the SSI. Some states up north do, and even out west, because of the cost of living is higher in those states. So New York, California, they provide a supplement on top. Florida does not. So the maximum for Florida residents is $794. So in addition to income streams, we have to be mindful of medical coverages. And I've got 4 different types of medical coverages listed on here, and then we're really going to get into the special needs trusts and how they tie into these programs. The first one is Medicare, and most of you are familiar with that, and hopefully you realize Medicare does not have financial limitations to it, so you can be wealthy and draw Medicare, and therefore a special needs trust is not necessarily necessary for that program. Medicaid is healthcare coverage through the state, and that is the program that has financial limits. And then we have our Medicaid waiver programs, which again, we're going to talk about that later on in a different session, but there's a program in Florida that is specifically designed to help meet the unique needs of individuals with intellectual and developmental disabilities, and that's a Medicaid waiver program. And there's also private insurance through the Affordable Care Act that individuals can get. And again, we're not going to go into any great detail in that, but the Affordable Care Act, the big difference is that there are no exclusions for pre-existing conditions anymore. So now you can get private insurance even for an individual who has potentially substantial disabilities. It may be expensive and it may not be easy to find, but there technically is a resource out there. So focusing on the SSI and Medicaid programs, these have financial limitations to them. There's also medical tests that you have to qualify for. You have to be disabled or elderly, which would be 65 years of age or older. And then this is our big issue. There are resource tests, both income and assets. And as a general rule, you can't give away your resources in order to qualify for these programs. There's a penalty, a transfer penalty, if you give away resources. And also the general rule is that trusts count as a resource. In particular, a trust that might be set up by the beneficiary, him or herself. That would be, generally speaking, a countable resource. So the special needs trusts fall into the exceptions to that. And as we mentioned before, special needs trusts go into 2 broad categories. There's the self-settled trusts, which is This is the trust when it's the beneficiary's money already. Well, why would the beneficiary have some money? Well, we're going to talk about that when we get to the self-settled trusts. But if they're putting their own money into a trust, there's a specific set of rules that apply. If it's anybody else setting it up, we call those a third party special needs trust. This can be a parent, a grandparent, or a distant relative or friend who says, I want to provide something for this individual beneficiary, and I want to set some of my money aside for it. You learned earlier that ABLE accounts can have either one of these sources of money. The beneficiary can put their own money in, or family members can put money in. In the special needs trust world, you can put third-party money in a self-settled trust. You probably would not want to do that, and we'll talk about why. You cannot move money from a self-settled trust into a third-party trust. That would not be an allowable disbursement, and we're going to talk about why there as well. But for these trusts, if you're not familiar with trusts at all, you should know that generally speaking, trusts have three parties or three people who are involved. There's the person who's setting it up. They're typically referred to as the settlor or the grantor. That's who's going to establish the trust. That would also usually be who's going to fund it, who's setting it up, though not always. We also then have the trustee. That's who's going to manage or handle the trust. And then the third party is the one who it's all about, which is the beneficiary. That's who's going to benefit from the funds that are in the trust. I'm going to take the third party trust first and talk about that because it's the easier one and the rules are not as complicated. So for a third party trust, as I mentioned, they're generally set up by a family member or a friend for an individual with a disability. Technically, you could set one of these up for your spouse, but you can only do it in your will, your last will and testament, which means when you die, it can be set up. So we sometimes do that, not necessarily for individuals with intellectual or developmental disabilities, but in our elder law community where we might have a spouse with dementia and we're worried about what we might refer to as the well spouse dying first and having the funds held in trust. So that's part of our general estate planning that we would talk with families about. Generally, these types of trusts are set up with a specific trust document for a specific beneficiary, which means it's custom drafted for that beneficiary. It's going to have who the primary beneficiary is. It's also going to have where those funds go if there's anything left in there when the primary beneficiary dies. And we can do that because there is no Medicaid payback for this kind of trust. That was referred to a little bit earlier in the earlier session, and a lot of people know at least a little bit about this. And so what we have to be careful about is that some kinds of trusts, not this kind, have a Medicaid payback when the beneficiary passes away. What that means is the benefits that the person received through the Medicaid program, the state is keeping track of that, and they have a lien against some kinds of trusts when the beneficiary dies to get paid back. And they get paid back to the extent that they paid out money. So if they pay out $50,000, they have the lien of $50,000 against some kinds of special needs trusts. Not this kind. That's going to be the other kind we're going to talk about in a few minutes. So for these third-party trusts, though, there's lots of different ways to do them. And I'm giving you a few here. We could probably even think of a few others. But one option is that we basically set up the trust now for the family member, and we go ahead and put some money in it. We may minimally fund it, but we get it going. We open a bank account. it's ready to go. That has some advantages to it because then we can advertise that to the rest of the family. And we can say, if you want to put funds into this trust for our loved one here, here's how you do it. And it makes it a little bit cleaner and easier. We can set up one of these trusts and we can leave it empty for the moment, and we can make it the beneficiary of things like a life insurance policy or even a retirement account. Or under a will, we can say, I'm going to leave Lillian's portion that I want to provide for her to this trust that's over here, and I name that as a beneficiary within my either legal documents or my financial planning documents that I might have, like beneficiary designations. We can also embed one of these kinds of trusts within a will, so that within my will, it might say, when I die and I'm going to be giving my funds out to my children, then I want to give half maybe to my son, who's an adult and capable. My other half is going to go to my daughter, but not outright. It's going to stay in trust for her. And here's the language within the document. This is how I want it to be administered and who's going to be in charge of it. So we embed that language within the special need, within a will or within a trust. We could also use what's called a pooled trust in this type of a vein. So if we don't want to set up our own trust and have to determine who that trustee would be and the financial advisor, there are existing trusts that are already in existence that we can participate in. We can just say, I put $50,000 over here into this trust for my daughter. It's still a third-party trust. It's still not subject to the Medicaid payback, but there's not then a custom trust that's drafted. It's already in existence, and basically it's going to say, this is how the funds would be utilized, and we can augment that by telling them some specific instructions, but there are ways to do it when there's smaller dollar figures, and we're worried about the cost of establishing a trust, or maybe we don't have someone that we know or trust within our family or within our support network to be in charge of such a trust. So there's ways to do it a little more cost effectively. The other kind of trust, the self-settled trust, these have very specific rules. These trusts must be irrevocable, which means once they're established, they cannot be changed. Why would we be setting up a trust, or what would be the source of the funds? Maybe the individual receives an inheritance that was not properly planned. It was not headed off in one of these other third-party trusts. So now we're stuck with having to do one of these first-party trusts. Also, there are lawsuits that occur. Maybe the lawsuit is what caused the disability, and there's now a recovery from an auto accident or a birth injury or something like that. But it could just be that an individual who's already on benefits is in a car accident, and they're recovering some money as the result of their injuries, and that personal injury settlement is going to cause a problem for them to be eligible for benefits, and we need to shelter them. It's also possible, maybe not so much with the population we're talking about today, but that an individual who's not born with a disability is working and saving, and they have a disabling event later on in life. And as you learned, if that's later than age 26, an ABLE account isn't even available for them. So like John mentioned, they have a car accident at age 27. They can't do an ABLE account, but maybe they've saved up some money and now they need to qualify for these other programs. This type of trust would be used to shelter those dollars. Because remember, they can't just give away the money and immediately qualify for benefits because they're penalized. Just real briefly, these types of trusts are set out in the federal law, in federal statute. There are 3 that would qualify as self-settled trusts. And I just put this up here because you'll sometimes hear these trusts referred to by the last 3 digits of the federal law. Sometimes they're called a D4A trust or a D4B, which in Florida is called a qualified income trust. or you might hear of a D4C, which is a pooled trust. So just so that if you hear somebody talking about, I set up a D4A, or we have a D4C pooled special needs trust, you might know what they're referring to. But basically, these trusts have specific rules, and the individual, the D4A, as the explanation kind of refers to, they have to be under the age of 65 when they set it up. And so establishing one of these trusts, the funds are then protected, continues for the lifetime of the beneficiary. But recall, all three of these trusts have a Medicaid payback issue to them, so that when the beneficiary dies, we cannot release any remaining funds to family members unless the Medicaid system is paid back in full. And so the payback can vary from state to state. The federal law says that the state is entitled to be paid back for all services provided during the lifetime of the beneficiary that is funded through the Medicaid program. Florida only recovers for Medicaid services that are rendered after the trust is funded for these kinds of trusts. So there will be a Medicaid payback. And I know the question came up earlier, can you get the Medicaid payback figure? We often are able to get the Medicaid payback figure before the individual has passed away, because if you're going to dissolve one of these kinds of trusts during the beneficiary's lifetime, you have to make the payback now. So what we do, because we administer a lot of these types of trusts, is that we can write to the state of Florida and say, we are contemplating dissolving this trust. Can you give us the Medicaid lien that's owed right now? It will help us compare. And I would say 99.9% of the time, we would not dissolve the trust, because we don't want to just pay that money to the state. It's gone. We would just want to keep the money in the trust and just continue to use it. And maybe we use it more liberally, and maybe we use it so liberally that the person loses benefits going forward, but we're not dissolving the trust still. Okay. And we cannot transfer any of these trusts outright to an ABLE account and close them out. We can use these trusts to help fund ABLE accounts, though, and we often do that. And so if an individual has one of these trusts, we can actually transfer the funds into their ABLE account and allow it to be administered as the ABLE account was described earlier. I wanted to just mention, of these three real quick, pooled trusts. Pooled trusts, like I mentioned before, can be helpful because these trusts can be more cost effective. They're much less expensive to set up and to administer, but generally speaking, these pooled trusts are going to be run by not-for-profit corporations, which is a federal requirement. For that D4C trust, they have to be established by a nonprofit, and that means that you can't, as the parent, maybe be the trustee. So you'll work with the professional trustee on administering the funds and determining how to best utilize those funds to pay for those extra things for your loved one. And many of these trusts do not have a minimum, and they can be very inexpensive to set up. And I just would mention that I think I may have mentioned, I started a pooled special needs trust 19 years ago. Ours is called the Guardian Pooled Trust. There are others out there, but we do administer these kinds of trusts. So I got a couple of more slides, and we're going to have a few minutes we can save at the end for questions too, John. The basic idea of these trusts are that we're going to keep the benefits in place and the money, and we're going to provide for extra things. The disadvantages might be that there may be some limitations on the use of some of these funds. In particular, if it's one of those self-settled trusts, they're going to have the Medicaid payback provision to them. And it can often be difficult to find a trustee who's knowledgeable and capable. And so you might be looking at a professional trustee, which then there are costs that are associated with that. And you'll have to decide if that's a good use of the money. This is the chart that I wanted to refer to, and I know John has taken this chart and has made a new and improved, and he's constantly updating this. I've made a few little changes to it, but we've now talked about, so up till today, you've now learned. I'm going to use my little pointer here. You've learned a little bit about able accounts. You learned a very little bit about that D4A trust that we were referring to. And remember, the D4C trust is the pooled trust. And then we've also talked about a third-party special needs trust. Remember, these two trusts have the funds of the beneficiary already put into them. They have the payback provisions to them, but that's one of the differences in these kinds of trusts. So what I've tried to do, I didn't do this intentionally to be a Christmas chart. I tried to do it more like a stoplight. I tried to find a trait that would be good. For example, growing tax-free. I don't think anybody could argue that that's a bad idea. So something that's good about an account, whether it's an able account or maybe a trust account, and make it a positive trait. And if the able account or the trust is positive for that positive trait, it's green. If it's negative for that, it's red, which means, maybe that's not good. And if it's orange, it's kind of like that yellow light that's getting ready to change to red, and you have to decide whether you're going to speed on through or you're going to actually try to stop, because it's not really necessarily crystal clear. So just kind of going through these briefly, can the beneficiary establish the trust on their own? Well, you've learned that an able account can be established on their own. A D4A can be established by the beneficiary, him or herself, and a D4C can as well. A third-party trust cannot. Well, that's not necessarily a negative, because the third-party trust works because somebody else is setting it up. But if we're looking for some flexibility, we kind of start off with who can set them up. The beneficiary can't do a third-party trust. That could probably be more orange, because that's a good thing too. That's why the third-party trust works the way it does. Limits on annual contributions. You've learned a little bit about some of the limits on the able account. The special needs trusts have no limits, so you can put as much as you want into any of these trusts, no issues. You know that it's $15,000 for the able account, plus you can put some more in if the individual is working and has some wages. We've talked about the Medicaid payback, and as we talked about, the D4A and the C trusts, they have a mandatory payback when the beneficiary dies. The third-party trust does not. And what we learned is that the able accounts, maybe they do not. As John mentioned, they release the funds that are remaining in the able account to the beneficiary's estate, and then it depends on whether there's going to be a claim for that Medicaid payback in the estate. John mentioned a couple of the things. If the beneficiary is under the age of 55, there is no recovery when the beneficiary has passed away. And there's no recovery for Medicaid services provided prior to age 55. So if the beneficiary is 60 when they die, you're only going to have 5 years of Medicaid liens to have to be concerned about. But if they're over 55 and they continue to receive Medicaid services, some of that money could be subject to a Medicaid lien. Can it pay for food and shelter expenses without impacting SSI? If you pay for food and then there are 9 specific shelter expenses out of any of the special needs trusts, it will reduce their SSI benefit. Catherine mentioned this a little bit in her discussion. If you pay for food or any of those 9 shelter expenses, and what are the 9 shelter expenses? They're pretty much everything you would expect: rent or a mortgage, electric, water bill, garbage removal, property taxes, those kinds of things. Not a telephone or cell phone, not internet services, but most any of your other utilities. If you pay for those out of a special needs trust, the SSI program will reduce the person's benefit. If you pay for them out of an ABLE account, they do not. So what we would want to do is, if we need to pay for some of those extra expenses, because the beneficiary's income is not sufficient, we would want to move money out of one of these other special needs trusts into the ABLE account, which is not income to the beneficiary when it's put in there. Sounds kind of strange. Mom or dad are going to move money out of their trust or out of their personal name and put it into the ABLE account for the person. It's not income. Then it can be used to pay for those expenses out of the ABLE account with no reduction in benefits. That can mean over a few years, thousands of dollars of benefit to the beneficiary by doing it that way, rather than having their SSI check reduced. We talked about, does it grow tax-free? None of the special needs trusts can grow tax-free. We weren't able to get that written into the tax code like the ABLE folks were able to do. And we talked a little bit about the lifetime limits on the size of the accounts. The ABLE account has that for every dollar over $100,000, the excess counts toward the $2,000 resource limit for SSI. And if there's more than 102,000 in there, your SSI is going to be suspended, but the individual continues to get their Medicaid healthcare coverage as long as we're not up to that $418,000 limit for that. So I've not seen any accounts to the 100,000 yet because of the limit as to how much can go in. Probably someone who's been putting $15,000 a year every year from the beginning and invested it very aggressively, they might be getting somewhere near that, but I don't think we're able to be there yet just because there hasn't been enough time. Under Florida law, Florida was able to make the ABLE accounts exempt from creditors. These other trusts, a third-party trust is exempt from creditors. The others may or may not be. I'm running out of time here, but as far as the ABLE account John mentioned, we can actually pay for a few things after a person passes away. And the D4A or the D4C cannot because they're subject to the Medicaid lien. And the fees that we've already talked about are very low for the ABLE account. And depending on how you set up these other kinds of trusts, you may be able to limit some of the expenses, but there may be cost of having a trustee or doing tax returns and things like that. So with that, John, I didn't leave as much time, but were there any other questions or anything we needed to talk about?
No, Travis, you did an amazing job. There was just a lot of information, and I thank you for tying in kind of your personal journey as well. That's always appreciated to hear from actual account administrators. There was one or two on here that, I just didn't know the answer because I haven't heard these questions before, but wanted to throw them to you. If a beneficiary is not on SSI or Medicaid, can the S&T use funds without any restrictions? So if, for example, let's say they're on DAC benefits.
Yeah, the short answer is yes. Well, if it's a D4A or a D4C, you can still only use those funds for the beneficiary themselves. You can't benefit a third party. But the short answer is you can still spend those funds on whatever they may need. And there may be reasons that you still want to have a trust for an individual who's not on those programs because they may not be capable of managing the money. And so we might still have a trust. We might call it something a little bit different, and we may have a little different guidance or rules for how it should be established, but it still probably would be a trust of some sort.
And then this last one I think is pretty interesting. Can a SNT S&T own an IRA or a Roth IRA and let assets grow, and then transfer those funds to an ABLE account?
And then transfer. Okay. The short answer is that a trust cannot own a retirement account. It has to stay in an individual's name. If we remember that the I in IRA is individual retirement account, they cannot be owned by a trust. You can make a trust a beneficiary of a retirement account, but the tax code requires us to look through the trust document to the underlying beneficiaries in using their age, or in some cases under the Secure Act now, whether that beneficiary is disabled according to Social Security's definition, because that would allow for a potential stretch out further of those required distributions upon death. So there may be a benefit to making a trust a beneficiary, but you can't make it an owner of a retirement account.
Well, great, Travis. I wanted to thank you once again so much for spending some time with us this morning. I know there's several questions that came in that had to deal more with Social Security type questions, which is great because that will be our next session in about 10 minutes. So we'll let Travis go for now. Thanks again, Travis. We'll give everybody about 10 minutes and then we'll come back and talk about the different public benefits, specifically with Social Security and the Agency for Persons with Disabilities. So we'll see you all in 10 minutes. Great. Thank you all, Travis.